Good afternoon, everybody. Thank you very much, dear Reda. And first of all, thank you very much for invitation to such an interesting conference. I'm really sorry that I haven't managed to reach Vilnius. It was my plan, but I failed due to technical reasons. And as Reda mentioned, I will be speaking shortly about Polish and Ukrainian perspective when it comes to selection of judges of the Supreme Court. And I must admit that this task is kind of difficult because Poland used to be like a success story till at least 2015, and as a good example of a successful transformation from communism to democracy. Now, as you all know, it's no longer the case, so I will have to be kind of critical towards my own country. But anyway, when Reda asked me to speak about these both perspectives, first I thought it's not good to combine, but then I thought that it will be really interesting to show how in the same period of time, two countries, two neighboring countries with a common history, with a lot of things in common, can move to a completely different direction. And first, I would like to start from the context when it comes actually changes, this very dramatic or radical changes in both countries in the context of judiciary. I would say that they both started in 2015. In Ukraine, it was a consequence of the Revolution of Dignity from 2013-2014, when Ukrainian society openly supported this European path for Ukraine, this goal to reach the rule of law in the country. And when we talk about the judiciary, then the level of trust to the judiciary was very low. It was also lowered because of decisions taken by many judges during the Revolution of Dignity. We are talking about these Maidan judges who took political decisions, who prohibited legal assemblies, who arrested protesters who were involved in the Maidan revolution. Also, judges in Ukraine were perceived as not qualified. The level of corruption, perception of corruption in Ukraine is still very high. In 2015, it was even higher than it is now. While in Poland in 2015, level of trust to the judiciary was about 44%, and it was slowly but steadily increasing. But the goal of the changes, all the changes within the judiciary, it's like a part of a global or wider plan, political plan to completely change the political system in the country, especially or particularly without amendments to the constitution. And in the picture, you can see the building of the Supreme Court in Poland with the big flag where it's written Konstytucja. I believe in all languages it sounds the same. But this sign Konstytucja on the building of the Supreme Court was also an element of a defense of independence of the Supreme Court. So in both countries, changes started in 2015. In Ukraine, it was the judicial reform strategy adopted, aimed especially at creating independent and effective judicial system. When it comes to Ukrainian reset, as I have titled it in the picture, you can see it here. And now you can see the building of the Supreme Court in Ukraine. And Ukraine decided to create a completely new Supreme Court. The reasons for this were, as I said before, so this lack of trust, politicized selection of judges in general, and perception of corruption mainly. And until this period, selection of judges politics were involved, because judges were selected by the Verkhovna Rada. There was lack of a transparent system of selecting judges, and this reform that was launched in 2015 by President Poroshenko, with support also of international experts, was to change this system. And in Ukraine, it was decided that a new Supreme Court needs to be formed. In December 2017, first 113 judges were appointed by the president upon the motion of the High Council of Justice. And in 2019, additional 75 judges were appointed. So in this moment, the Supreme Court of Ukraine is fully operational, is filled with almost 200 judges, what makes it one of the biggest Supreme courts in Europe. What is very important, Ukraine has changed completely the process of selecting judges by forming judicial bodies involved in this with guarantees of its independence. And in the process of selection of judges in Ukraine, the crucial role is being played or shall be played by the High Qualification Commission of Judges, which does not exist now in the moment. I will tell shortly about this a little later. Which was responsible for conducting a competition to the Supreme Court. Decision whether to appoint a person, a judge of the Supreme Court, is being taken by the High Council of Justice, and High Council of Justice in Ukraine is formed in accordance with the best European standards. So majority of members of the High Council of Justice, these are judges. There are also representatives of President of the Verkhovna Rada of the government. So this is the body which is aimed at protecting judicial independence and efficiency of judicial system. And the process of selecting judges of the Supreme Court lasted altogether more than 2 years. What is very important, the Supreme Court was open not only for judges, or the competition for the Supreme Court was open not only for judges, but also for lawyers, representatives of academia. And it has a significant impact on the composition of the new Supreme Court, because there are a lot of fresh blood, we can say. So there are a lot of former lawyers, former academics who bring like a new approaches to the Supreme Court. The process was very complex. There were a few stages. So any person that wanted to apply for a position of the Supreme Court judge had to file a determined set of documents to prove his or her competences to be appointed as a judge of the Supreme Court. With the moment of filing documents, such a person was vetted because the High Qualification Commission asked for a verification or information from various bodies which operate in the area of fight with corruption. So this is, for example, National Anti-Corruption Bureau. These are tax offices. These are various bodies who collect information about the property. So this is like the very initial element, the very initial stage of the selection process. Then a person who was admitted, who was meeting formal requirements to be appointed as a judge of the Supreme Court. So this, of course, education, citizenship, knowledge of the language, proper professional experience, was admitted to the stage which consisted of legal tests or legal examination. So it was not only like a legal test of legal knowledge, where candidates had to answer questions from various areas of law. And objectively, I think it was a big challenge for many of them, because judges used to specialize. So they used to specialize in civil, criminal law, or administrative law. And during this legal test, they had to answer questions related to, or questions from various branches of law, which definitely is a challenge. After this legal test, there was a case study. So each candidate had to decide a model case study, and this case study this practical task was further assessed by the high qualification commission. And what is important, each work was assessed by at least 3 members of the High Qualification Commission to avoid and like a joint joint evaluation was taken into account. These candidates who went through positively through this legal test that actually allowed to verify their professional competences, they were admitted to the next stage of the examination, which was conducted by the High Qualification which consisted from other steps or 2 phases of this examination. First of all of them had to go through psychological testing, and it was a very complex task, because it was not only like a psychological testing through solving or answering questions. So answering questionnaires that were developed by a team of psychologists, Ukrainian psychologists, also with assistance of international partners. But all of them were interviewed by psychologists who were assessing their competences, their weak points, their strong points, and they prepared like a psychological picture of a candidate. Only then all these documents were reaching the High Qualification Commission as such. So there were results of tests of legal competences. There were results of psychological testing. There were documents which were filed by the candidate. There were also information gathered from various bodies involved in the process. And there was also opinion of Public Integrity Council, which is also a very interesting solution applied, I think, exclusively in Ukraine. The whole process of selection of judges of the Supreme Court was transparent, and this transparency started from this that all the lists of candidates were published. Declaration of assets, declaration of their family members, declarations of integrity, which were filed by candidates, were also published. They were accessible online. And in these declaration of assets, a candidate had to inform about the property, about the money, about the loan, credits, etc., not only of him or herself, but also of members of the family. Another declaration was connected, so there were like 3 declarations. The second one was connected with family members who are involved in government positions, because this is important also to assess like for assessment of the background of the candidate. And also another important declaration was declaration of integrity, where a candidate had to declare potential risks or situations where when the integrity could have been questioned. A significant part of this questionnaire was related to decisions taken to this whether a specific candidate was involved in taking decisions which were perceived as which were taken in a context of Maidan revolution. So whether there were kind of controversial decisions or decisions which were illegal. The documents of the candidates were published online, of course, with respect for duties resulting from data protection law. And also, what was very important, and I think very stressful for candidates, it was that the interviews that were conducted by the High Qualification Commission were live streamed on YouTube. The interviews were. It was the final stage. It was the final stage of the process of qualification or of selection of candidates for judges of the Supreme Court. And during these interviews, high qualification members, they were they had at their disposal a set of information about judges, about candidates for judges. So it was also an opportunity for the High Qualification Commission to clarify some controversial issues, to ask additional questions, also to clarify questions connected with their integrity. And when it comes to integrity check, a very significant role in this in assessment of integrity was played by the Public Integrity Council. The Public Integrity Council, it is an advisory body that was formed under the relevant legislation, composed from representatives of the civil society organizations who were involved generally in all activities to promote rule of law, to promote independent judiciary, to fight with corruption. And the Public Integrity Council the members of this council were conducting a check on integrity of candidates for judges. So to fulfill this task, they were using especially open data. They were using information from social media also. So they were collecting data. They were preparing their reports, indicating that some candidates for judges did not meet criteria of integrity. Especially according to them, many of candidates, of judicial candidates, had doubtful property. So there were these corruption risks. So these kind of questions were being assessed by the Public Integrity Council. As a result of their process, their involvement, the Public Integrity Council was allowed to present negative opinions about candidates for judges of the Supreme Court on the basis of their findings, and they actually about 30% of their negative opinions that were presented with the High Qualification Commission were approved by the High Qualification Commission. So it means that about 30% of candidates were disqualified from the process of selection for judges of the Supreme Court on the basis of findings that were done by the Public Integrity Council. And the procedure was constructed in this way that when the negative opinion was presented by the Public Integrity Council, the High Qualification Commission was voting on it, and to disregard this negative opinion, they needed like a qualified majority. So a majority of 11 votes from the High Qualification Commission members was needed to disregard the negative opinion of the Public Integrity Council. And on one side, the role of the Public Integrity Council was definitely positive because thanks to their involvement, it was possible to identify some candidates for a position of judges of the Supreme Court who should have been disqualified, and they, in the end, were disqualified from the process. On the other side, there were some tensions connected with involvement of this body in the process, which resulted from maybe not fully properly considered or thought a model of their participation. So the Public Integrity Council was to be more like advisory or assisting body to the High Qualification Commission. Later, it occurred that there was like more adversary approach. So the Public Integrity Council perceived themselves more like prosecutors in the case than assistants to the High Qualification Commission. There was also a tension which resulted also from the fact of from the lack of proper regulation in the law. What about the burden of proof? Because often the opinions which were presented by the Public Integrity Council were assessed by the High Qualification Commission as not sufficiently grounded or as not proven. And there was the question whether it should be like proven lack of integrity, or is it sufficient at this stage, at the stage of the selection of judicial candidates to the Supreme Court, whether it is sufficient to indicate for these reasonable doubts which may justify disqualification of a candidate. And from a perspective of time, we see that in Ukraine, the Supreme Court adopted the approach that it should be proven. We see it now from decisions of the Supreme Court, which were taken both in the process of selection of judges or also evaluation of judges in Ukraine, but also in evaluation of prosecutors. So they expect, or they require, the Supreme Court requires that allegations as to lack of integrity are proven. It is not sufficient that there is like a reasonable doubt existing. So the burden on proof that there is a lack of integrity is on the High Qualification Commission. So it is more like the approach from the criminal proceedings, objectively. Yeah, and very shortly about the situation in Poland and the selection of the Supreme Court judges. So the Supreme Court judges, I'm talking about this, what is happening now after all these amendments to the law on the Supreme Court, which were finally adopted in 2018 after a long battle. These amendments to the law, which are being challenged before the European Court of Justice, some of them already decided as violating the EU law. But under the current law on the Supreme Court, two new chambers in the Supreme Court of Poland were formed. One of them is the Extraordinary Chamber, and the second one is the Disciplinary Chamber. These two chambers have a special status within the Supreme Court, what is also one of the grounds why they are questioned as being independent courts, because they're like special courts within the Supreme Court. And the selection of judges to make it more informative or more picturesque, I would say. Selection of judges of the Disciplinary Chamber, the competition was announced like 30 July 2018. The list of candidates or the list of applications was closed 2 weeks later, and there were about 240 candidates. They were the procedure of selection of judges of the Supreme Court of this chamber was conducted by the High Council of Justice, which is also perceived as not meeting standards of this body, which is aimed at proper selection and judges and protecting judicial independence. And there were like about 240 candidates for the position. Significant part of the candidates were so-called kamikaze. So these kind of candidates who wanted to apply or who filed applications and wanted to be involved in the process only to challenge the legality of the process later before the European Court of Justice. And this is happening, or this has happened. We are still waiting for decisions. And the High Council of Justice received dossiers of the candidates for positions of judges in the disciplinary chamber. As I said, it was more than 200 candidates. Interviews with these candidates were conducted during 1 week, actually 1 working week, so it was like 5 days. The interviews lasted about 15 minutes with a candidate. The pressure, there was a huge pressure from the side of the Minister of Justice, who at the same time is the Prosecutor General in Poland, who was pressing that the disciplinary chamber needs to be formed as soon as possible because the judges need to be disciplined, they need to be controlled. And as a result, there were 13 judges of this disciplinary chamber elected, and half of them are former prosecutors who are connected with the Minister of Justice. So there is no transparency, no integrity check, actually nothing that could be promoted as a good lesson. So this Polish experience now serves as a negative lesson. Yeah, and we are waiting, just a month ago, there was the latest opinion of the Attorney General at the European Court of Justice, who assessed the disciplinary chamber of the Supreme Court in Poland and extraordinary chamber of the Supreme Court in Poland do not meet standards of independent courts. So this is like a set end of my presentation. Thank you very much for your attention.